We are back on Morning Line. Thanks for joining us talking elder law. Our guest this morning is Barbara McGinnis with Takacs and McGinnis. It's always good to have her with us. Barbara, we had a caller that waited through the break that had a question for you. Why don't we take that off the top before we continue, and we'll go to Ricky. Are you there, Ricky? Good morning.
Yeah, good morning.
Hi.
Yeah, I got a question. I got a house, and we ain't got no kids. How do we leave it to a friend of ours after we're gone?
Okay.
All right. So real estate is an interesting asset, and it has, it's going to pass by joint ownership. You own it with your wife now. So the first spouse to die, the surviving spouse is going to own that asset. But if you want to pass it to someone after the surviving spouse, then a will would be a great way to pass that asset. A will would be admitted into the probate process, and through that, the authority of the executor, the authority of the court, then the asset could be passed along to whomever you name in your will. Sure. A revocable trust is another way of passing on an asset for real estate.
It's fairly straightforward, and I appreciate Ricky making that call, but it's no different for real estate or anything else. If you're putting a will together, you can decide who you want to give your assets to, whether it's direct family members, friends, or you want to leave it to an organization like a humane society or something like that.
That's right. That's right. So a lot of times people, this is one of the frequent mistakes or misconceptions that I see, is a lot of times people think when they have a will, they do not have to go through probate at death. A will does go through probate at the death of the testator, the person that wrote the will. But what it does is it allows your wishes to be executed, to be carried out, instead of the intestate plan of the state. So the intestate plan of the state, I die without a will, it's going to go to my spouse. My spouse is not alive, it's going to go to my children. If my children aren't alive, then they look to see if my parents are. There is a natural order of progression of who would inherit, and it follows blood. If I don't have a will or trust that says how I want my assets to pass upon my death, like the charitable contributions, like a friend, someone who's not a blood related. And a will goes through probate to get authority and to take effect. A trust does not go through probate to take effect. And part of the reason is because the authority of a trustee, the person that's managing the trust itself, continues on after the death of the person that creates the trust. We call that person the grantor. Some other terms are trustor or settlor. But the trustee then can continue on administering the assets of the trust. That's why a trust usually can avoid probate process. So a will is not all you need either. People do need to have a will because it's important for their wishes to be memorialized, their intent to be memorialized. But you also need documents that can help protect you during your life. A will really is only an instrument that follows death of the testator. Powers of attorney can protect people during their lifetime if they become incapacitated. Incapacity can be temporary, or like maybe following a surgery, it's temporary, or it can be acute. Maybe you're in a car accident and you're suddenly incapacitated, and hopefully it still is temporary. So there's all kinds of situations. It's not just because I become older, frailer, I have some memory impairment, or there's, I think that's what people envision a power of attorney is for. I'm going to become old and incapacitated. Well, sometimes young people become incapacitated, or middle-aged people, and you need someone that you trust to have the authority to continue to manage the business of you as a person. Even if that person is your spouse, even if that person is a joint owner on your bank accounts, they still need some legal authority, and we need to give that to them.
Are you telling me, though, Barbara, whenever anyone dies, okay, it ends up getting into the system one way or the other, and there's probate? I mean, what about? I mean, how do they find out about it? If you know, there's a family and the father dies and the mother just, you know, obviously they deal with the burial and all this, but you know, and they get the death certificate, I guess it's made public. But I mean, if you don't go to probate, if you just ignore it, I mean, there's no police department coming over and saying, hey, get your butt in probate, is there? As long as there's not a dispute among the heirs, does every case end up in the system? And if it does, how the heck do they find out about who dies? And who's monitoring that on a daily basis?
Well, there's not a probate police, and there are many ways that will drive you into the probate court, though. Okay. So perhaps your mom and dad own the house together. Dad dies. Mom's the surviving joint owner. Then mom dies. Well, so if mom has children, say you, and you want to now sell the house, your title company may not let you sell the house until you go through the probate process.
Now, why would that be? Why would that be? I mean, you're right. Okay, so mom dies, all right, and I don't know if there's a will already, but let's just say me and my brother decide, okay, she's died, let's just sell the house and split the profit, you know. Okay, so the title company would say, well, wait a second, it's in your mom's name. I go, well, my mom's dead, so I want to sell the house, all right? I'm her son. Here's my proof. Let's do this.
Yeah. And so whether there's a will or not, they may ask you to go through the probate or insist that you go through the probate process, largely to ensure there are no creditor claims.
Oh, okay. Okay. So
in Tennessee, title companies often want to see the probate process to make sure there's not any creditors, and one of the primary creditors they're looking for is to make sure they are TennCare does not have a lien against the property. Sure. And as you know from listening to Tim talk for years and years, TennCare does not place an actual lien on property. It's just the state has a right to recovery from the estate of the deceased TennCare recipient. And so it's not an actual lien, but in a way, it's sort of a practical lien. They're a super creditor, and title companies are going to want to make sure that there is not TennCare lurking in the bushes wanting a piece of that house.
As we go to the break, real quick question. You talk about credit and all of that. If you have a parent who has a credit card for whatever reason, they're broke at this point, short of Social Security or whatever they get, and they run up a huge credit card bill and then die. And there's all that credit money that they owe, all right? I suppose the credit company, if they had any assets, could file to recollect some of the money after they die. But if they have no assets, does that automatically go to a family member, or that's just a clean loss for the credit card company?
It's a loss for the credit card company. Unless you're a joint owner on that card, that you have no responsibility to pay that. It's an unsecured debt. So it's unlikely a credit card company would open probate on an estate because they are unsecured. But a lot of times creditors can open probate themselves if the surviving heirs do not.
Interesting. And in your experience, have you seen that before, where a family found themselves with someone who died who left a huge amount of credit card debt that they didn't realize? And does that happen very often?
It happens more often than you think. It really does. Yeah.
Wow. Listen, let's take a break on that. That's really interesting stuff. When we come back, some more calls for Barbara McGinnis, the number 737-7587, and we'll get more of her pearls of wisdom right after this. Stay with us.